Hey guys, and welcome to today's video. Today we have a Karen in court who doesn't want to stay at the property she signed a rental agreement at, but also doesn't want to move out, but at the same time has already moved out. Have 2 hearings to get through, and it's a bit long. So let's begin.
Folks, that's the call. Please move along to your calendars. I asked if you have multiple cases, attorneys, that you try to handle them as many as possible before you come to me, and then we'll address them in turn. I'll look at those defaults shortly. Thank you.
Your Honor, as far as Kiana Johnson, with this case with Pharrell, I'm in the hospital, so I'm trying my best from the hospital. I just got it. I did submit a letter saying I was in the hospital. I don't have my ADA accommodation, so I'm not familiar with how this goes. Can you please tell me what's next?
Yeah, so all we would do, ma'am, and I really do pray for your swift recovery, whatever that may be, but ultimately it's virtual, so you would be able to still talk with that attorney in a private breakout room virtually.
Okay, I just need to know. Okay, so you all will do that. I don't know how to.
They will put you in a breakout room. You'll see an icon, and folks, this is for everyone. You ultimately will see an icon that says join breakout room. Do not leave the actual hearing, this Zoom hearing, unless I tell you to, okay? I'm the only one who can dismiss you. But ultimately, you'll be placed in a breakout room, and you may have to wait because one of the attorneys may have multiple cases, and then they will address your case in turn. Ms. Johnson, they may try to get to you sooner because you're in the hospital, but we will see. And then ultimately, you'll have an opportunity to determine if you want to settle the case or if you want to have a trial, okay? And if you have a trial, we'll have to have that situated. So just be on the lookout, folks, for that icon to join, and then you folks are free to do so.
Sorry, that was my doctor. Sorry.
No problem. Thank you for being patient. If you can raise your right hand, we'll get you out of here. You swear affirm to tell the truth under penalty and perjury of the law?
I swear.
Counsel, give me 1 second. What are those terms?
Judge, this one's a little different, just to be kind of very open and frank with the court. So it's going to be an agreement. Both parties are going to dismiss with prejudice their claims and their counterclaims. Miss Johnson's lease ends on September 30th. She has agreed that if her stuff is not removed by September 30th, those items will be deemed abandoned.
Okay.
And if Mr. Thomas, who is the plaintiff, he and his wife own the property together, that if they find anything like that she leaves behind that may be considered valuable, that they will notify me and I will reach out to her and arrange for her to be delivered that.
Okay.
And then with respect to the security deposit, that the parties are going to sign a mutual release, and that when that is presented, they will sign it, and then after it's been signed, which I will prepare and give it to Miss Johnson by hopefully tomorrow, that the security deposit of $1,000 will be paid towards her, available for either pickup at our office, or I will be happy to FedEx it to wherever she wants me to FedEx it to. Does that make sense, Your Honor?
A little bit, but let me see.
Sure.
All right, Ms. Johnson, just to confirm, I just want to confirm the terms. The parties are both dismissing their cases, claims against one another, but ultimately you've agreed that you will move out your remaining possessions on or before 9/30/2025, and anything remaining will be deemed abandoned. However, if there is anything that deems valuable, the parties will hold and contact you so that you may retain it or kit it. Moreover, the security deposit will be addressed upon your move out, which you guys will do a move out walkthrough as well. Counsel, is there anything else? No money judgment?
A negative. The security deposit's not quite right, Your Honor. So it's basically she's going to waive a right to, or we're going to waive our right to the security deposit. We're just going to give her $1,000, and she's going to sign a release, and my client will also sign a release.
Okay, so forgive me, Ms. Johnson. So in lieu of that, you will get $1,000 portion of the security deposit, or just $1,000 just in general.
Yeah, as a judgment. Yeah.
Yeah, and then that will resolve the security deposit issue as well. Anything else that I missed? I'm sorry, you guys got quite a bit.
Is that correct, Mr. Pharrell? It's not the security deposits. It's just $1,000 judgment, correct?
Right.
Well, it's not a judgment,
No.
but
No. I didn't say anything about a judgment. We agreed on $1,000 of the security deposit. I don't want any judgment against me or my business or our company. A judgment? Am I clear?
So what is the clarity, Mr. Farrell?
Yeah, can you clarify?
okay, sure. I guess it really is coming from the security deposit, but maybe I shouldn't use that word. There'll be a waiver of the security deposit. My client will pay her $1,000 upon the party signing.
Alright, so this is going to be a point of contention throughout the video. Basically, the landlord is asking her to drop any claims that she has or may have against the landlord, and in return, he will drop any claims that he may have or will have against her.
I know Mr. Attorney Farrell is clear as well, but the security deposit, they're not going to be keeping all of it regardless. Out of that, you're going to get $1,000 of the security deposit that you've already paid, and that is upon signing in a mutual release. Again, the parties are dismissing their claims against one another. You'll have to the 30th to remove your remaining possessions. Anything remaining will be deemed abandoned. However, they will keep it and potentially, if it's valuable, and contact you about it. Furthermore, upon that. Yep, that's what life likes to do to you.
Your Honor, if I may, just for clarification, she used the word judgment, and I'm no lawyer, but we didn't agree on any type of judgment. This is a mutual, amicable agreement.
I got it, Mr. Thomas.
Yeah, no judgment. We had an agreement.
I understand. But I need to wait for her to come back.
Yes, sir, I understand. Just
Ms. Johnson, can you unmute and turn on your camera? Go. Can you unmute for me?
Yeah, I'm sorry about that. I'm getting blood drawn and it just.
I get it. We're gonna make it real quick.
Okay.
You agreed that the terms are that you guys are dismissing your claims against one another, that you're going to be vacating on or before 9/30/2025, that any possessions remaining will be deemed abandoned, that anything that deems valuable they'll contact you about. And furthermore, you'll do a final walkthrough where ultimately, after you sign an agreement, they will return $1,000 of your security deposit. Are these the terms that you've agreed to?
Yes, the walkthrough of the security deposit would be returned, he said, within the next week.
Okay, well, you guys would also be required to sign a mutual release.
Yes.
Okay. Well, then I will get a proposed order from council, which I'll review and sign, and then I will get a copy over to you. And I pray that you do well and you get better, okay?
I appreciate it. Thank you.
All right, you guys are free to go.
Thanks, Judge. Appreciate it.
Leaves and loses her security deposit, and he pays her $1,000 minus any damage to the unit beyond normal wear and tear. No judgments, no evictions, just you go your way and I'll go mine. And please never contact me again.
Yes.
Did you or Mr. Attorney Sinquit have an announcement?
Your Honor, I do. I have a pay and stay agreement on position number 4. And I still have one more tenant to talk to. And I know the court's considering position number 1.
Yeah, and so I just real quick so I can get to deal with Ms. Johnson. Ms. Johnson, raise your right hand. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
All right, so listen, I've read over your motion. I do see that the original judge had given an order for you to pay in the registry. I do understand that you had certain other conditions and that it was ultimately, that may have altered your ability to do so. And then some other things occurred. Those issues, though, don't necessarily materially address the issue of possession. They're totally fine for counterclaims, but they don't address the issue of possession. Obviously, your condition would really justify you leaving the property, right? So,
may I speak?
Sure.
Okay, so as far as the position there, I did go into the property with an ADA need. I had an allergic disorder. That was addressed to the homeowner, and he said that he would make sure that there were no allergens in the home while I was there. A major allergen would be mold. That resulted from an unrepaired and unresolved and refusal to resolve without in a manner appropriately and timely. And that
Objection.
I would before.
So
Your
I'm
Honor, this,
going-
we dismissed the claims and the counterclaims. I think we're in front of the court on a motion to enforce what she contended is an oral agreement. It has nothing to do with everything that happened before.
Your Honor, I'm not.
Well, hold on. I see an
Okay.
order. I see an order for continuance. I see a motion to compel rent and an order regarding such. I don't see a consent order, but I do see the motion to compel rent into the registry, which is the basis, I believe, why the writ was requested, because the $1,300 was not paid in the registry. Is that correct?
Your
No,
Honor,
Your
this
Honor.
You said
You-
no.
No, Judge, you signed an order that should be part of the record, which I can, share with the screen.
Hold on. If it's then, I'm sorry. I saw them. It seems like there's been two judges. I see Block's been on here as well. So hold on.
Mm-hmm.
I see this oral agreement, but counsel, you're saying there's a different agreement? I mean, this alleged oral agreement where she's.
Judge, you signed an order. It should be in the docket. I can share the
Your Honor,
screen.
if I could, I think I had the position first. He objected. Can I go back to my position?
Just hold on. I want to see what I'm looking at first. Okay, so there's a consent agreement. That's important. And so the consent agreement indicates parties have agreed that defendant Keena Johnson and all others will vacate the property located at 2179 Diller Crossing, Tucker, Georgia, on or before September 30th at 5 p.m. and that anything left behind shall be deemed abandoned and may be removed without further order of court. Plaintiff sees anything valuable. Yeah, I feel like I remember this case. Further ordered and the judge, plaintiff's complaint, defendant's counterclaim. Yeah, so I understand what's going on. Today's the 30th, Ms. Johnson. You signed a consent agreement. I'm not trying to be difficult with you, but there's generally no appeals, of the consent and modification of such.
Your Honor, I'm respectfully asking under my conditions for a chance to speak.
Sure.
And I'm gonna speak by narrative, if you don't mind.
Well, I would ask that you just be respectful of the time and
Yes,
address specifically. So hold on. Let me ask this. Why do you believe that the consent order which you signed, saying that you would vacate by the 30th and dismiss all your counterclaims, why should that essentially be not considered in lieu of your signature on such, or in lieu of the agreement that I find that you've entered into?
Your Honor, the reason being, and before I go into that, I will say that I did ask for ADA accommodations. I am a disabled party. I asked for ADA accommodations. That was requested on August 26th. Before that, in a different way.
All right. So that's the end of the first hearing. I left it in for two specific reasons. First, to hear for yourself what the actual agreement she and the lawyer had, and also for another reason, which I'll cover later.
Objection.
And so
Under one
for me to
basis,
be able
Attorney
to,
Farrell, just so I can keep a record of what's going on. Objection for what?
Well, that's not the motion from the court, Your Honor. I'm objecting. The motion from the court is the motion to enforce the settlement agreement.
Your Honor, in order for me to have due process in this court, I do require ADA accommodations for cognitive disability.
Well, ma'am, are you trying to say then that you didn't have the authority to enter into the agreement that you said you had the authority to enter the agreement back on September 2nd?
No, okay, I needed, because I have a cognitive disability under stressful situations, this is why those accommodations were needed and the breaks.
Well, how do we address that accommodation? I'm not trying to be rude.
There were a list. There were about 7 accommodations. When I'm in another county, I get an ADA coordinator that I work with. I have been asking for a DeKalb County coordinator. I have not been given that. I've been told that we had to wait on the judge to at least address the ADA accommodations. They were asked for reasonable accommodations. Those were not addressed. Those were not addressed at the last hearing. That is not what I'm saying. I'm saying for me to continue forward in the manner in which we are, I'm going to put down that I'm not receiving those accommodations. I need to put that down on record. Part of those accommodations would be a support person for this hearing. Part of those accommodations would be breaks. I just got out of the ICU. My condition has been exacerbated. I've been in the ICU all week. That's another reason for the emergency continuance.
But continuance for what though? But why?
But that's why the ADA accommodations come in.
But we don't really need a hearing. And I'm not trying to be difficult, but you have to take this in consideration of how I'm viewing it. Before these things, or after these things were requested, you voluntarily entered into a consent agreement, right? Your Honor, don't cut me off. That's how you get nowhere. Why would you cut me off? That's foolish. So you've entered into this agreement on the 2nd of September, just less than 28 days ago, right? And
not this agreement.
Well, the agreement says September 2nd, and that you'd vacate by the 30th of September. I understand. Stop talking. I understand your physical conditions have changed because of your health, but that does not necessarily disregard the fact that you've entered into a consent agreement indicating when you would vacate. Your ADA accommodations are not relevant because really there'd be no need for a hearing based upon the agreement that you've already entered into. So I'm trying to figure out why we need to accommodate in those regards when you've already entered into this agreement indicating that you would vacate. You've created the time to prepare to leave. That was what your plan was.
Your Honor, may I?
Yeah, you can now, yes.
Okay, so Your Honor, I've had these disabilities for years. It's not just because of this. They just been exacerbated by this. The other reason is that when I had the hearing last time, I had the hearing from a hospital bed. I had just had a stroke. I had just had, that morning of the hearing, I had just had an MRI and Xanax. I had just had a procedure. I got to the hearing late. When I got to the hearing, I was right at the point where you all were going to give a default judgment, but then I said hello, and then I proceeded from my hospital bed and my hospital gown. I didn't want to be under those same similar circumstances, under medication, and having this. What I'm saying now is that the reason that I bring this matter back to enforce is, one, because what you signed was not what we agreed to verbally, and not what.
And what exactly does your mental deficiencies have to do with your voluntary order to vacate the property? And I don't know about you guys, but this is the first time I've ever heard of mold exacerbating a learning disability.
That he originally sent to me to sign was about 5 pages long. There is history with this counsel, and he did not disclose that. I did try to disclose that with you before, which may be a conflict. The history being is that we're on a similar case in another county, and that similar case it has the same similarities, health-wise, landlord-tenant-wise, but that case is confidential. The reason being here is that I just found out today that he subpoenaed my medical records. He subpoenaed my medical records, and I just found that out today. I was just giving that. Let me
stop. And I understand your situation, but I'm again looking at my notes from that hearing on the 2nd, and it says consent vacate by 9/30/2025.
And that's about all it says. But the agreement that you signed, that he had you sign on September 10th, we have been going back and forth after the hearing since then. He tried to get me to sign something that was totally different language than what you said in court.
But I'm only referring to what I have in court.
Yes, but what he drafted for you to sign is not what we went over in court. That is not the agreement we made. It does not only say September 30th, get out. It does not only say that.
It says the property that you'll have and anything deemed, and they'll essentially keep a value and try to have you talk through counsel. So listen, I respect you and understand that you have certain conditions. I'd like to remind you that you're telling me that the property is uninhabitable while also trying to demand to stay in the property.
I'm not asking to stay in the property. I've already addressed in my motions that I have signed a lease somewhere else. I have been out of the property for the last 3 months. The issue is that I cannot, it's uninhabitable. I cannot go in and get my property, which includes my dad's ashes, my son's autism medications, all those things.
Who can go in?
The property, I have tried to.
Are you there right now?
When I tried to go in.
Are you there right now?
I don't live there right now, but all our belongings are there.
Are you in the property right now?
What do you mean?
Are you physically in the property right now?
I am in the temporary housing property where I signed a temporary lease. I'm on my 3rd month of rent. Okay. Because that house is uninhabitable.
And that's fine, but that has nothing to do with ultimately you getting the remaining of your possessions out between the 2nd and today.
The agreement.
So listen, respectfully, what I do know is that you've agreed to vacate. There's nothing in here indicating that you are required to pay rent or anything like that in the consent agreement. So Attorney Farrell, I'm not sure about the writ that's been requested, because I believe the writ indicates that she's missed a payment. Now, I believe that may be associated with a prior order from the prior judge about being paid in rent, but it appears that the most recent order and the most that would be effective is the consent agreement that was done on the 2nd, indicating that she'd vacate by the 30th of 2025. That's it. So whatever your writ wouldn't be signed as is currently identified, because that's based on a prior order that has essentially been overtaken by the consent. So at this juncture, I would need a new writ. Ms. Johnson, what I would tell to you is that they have to submit a new writ. I do have a consent agreement where I have you under oath confirming to those terms. The end of information here.
Right? Because what was said in court was off the cuff and in layman's terms. What was given to you was in legal ease and said the exact same thing that was said in court. You leave, drop all the claims against the landlord, and in return, the landlord won't pursue any claims against you. He'll keep the security deposit and pay you $1,000. Minus damages to the unit above normal wear and tear. It really doesn't get any simpler than that.
Ordering the judge, parties will sign a mutual release and will not cover damage of any of those property defendant can. So you guys never signed that release. I see that was I guess that's the oral agreement that you guys have been referring to.
I'm trying to continue.
Be paid $1,000 from her security deposit for fitting the remainder.
They added language to that consent agreement that was not part of the agreement is what I'm trying to get to.
Okay, and which part?
It's the part where they say that the $1,000 security deposit, they have, when they presented me with an agreement to sign, the release to sign in order to, there was no contingency basis, first of all, for me to sign that release in order to get that $1,000, but they put that down there. They also were supposed to, if I didn't get all my things out, given the consideration of the situation, they were also supposed to, they agreed that I would give them a forwarding address. They would allow me to get some of the most personal, valuable things back. And so they changed that.
It says if plaintiff sees anything valuable. Well, and that's not what it says in the order. It says if plaintiff sees anything valuable, plaintiff will reach out to defendant through counsel to have it picked up.
No, they agreed not to pick it up, that they would give it to an alternative address. They would send it. The other thing is that
negative, Your Honor.
So Ms. Johnson, I'll be frank. You know, I'm going
to file a motion today. Go ahead.
You can do what you want because that's what's legal. I'm not.
But that's not what the agreement. My argument, Your Honor, respectfully, is that there's more to it than that. That is not what the agreement was. When they tried to sign the release, they tried me. The reason I bring up the other case is because the other case had language that he tried to include in this case. This case had simple language, and he gave me a 5-page thing to sign that excludes that, and the other.
I understand, but all I'm saying, Miss Johnson.
You got to give me a chance to finish under these conditions. I do. That's why the ADA accommodations were necessary. They're not because
it has nothing to do with that. If I'll be frank with you, your ADA accommodations don't justify. You're speaking fine. You don't. You're not sound. I'm just telling you. You don't. There's nothing that you're saying that doesn't seem as if you don't grasp what I'm saying or that you need aid. And indicating what you're telling to me is that you have an issue with this particular order. One of which I'm not quite sure because what you've already said is that what's on this order, which is 1 page, right? 1 page. So I'm not sure about what else you're talking about, but the order that I'm referring to is 1 page. And I've already read it. And it's a consent agreement.
There's one more thing, Your Honor, if you let me. On the order, when we talked about this, the security deposit, it was in lieu of the security deposit. He was not allowed to go and what he tried to put in the new agreement for me to sign in order to get the $1,000, that was cost to help me move out, not for him to move me out, but for me to be able to get my things out.
Let me just read it so I make sure that you are reading. So it says in this last portion, further ordering the judge, the parties will sign a mutual release agreement. The mutual release will not cover damage, if any, done to the property by defendant or any other occupants. When defendant Kiana has signed the mutual release, she will be paid $1,000 from her security deposit, forfeiting the remainder.
No, Your Honor. What they basically, I still have to sign their version of a release to get that $1,000. I was not able to do that because their version of that release does not state what is on that order. It actually states that I'm sorry. This is where I probably need a break, but I don't have those accommodations.
Well, how about we do that? Why don't I give you a break and I'll move on and I'll come back.
I can give you.
I think it would be appropriate based upon everything that you've made clear to me that it may be best for you to have a break. I'm not making an order yet. So why don't you take a break and we'll deal with the other cases.
How long will the break be?
We'll see. I'll see how long the cases will take.
Okay.
A break is better than no break.
That's fine. I did want to put out there that I would like to request to disqualify Attorney Farrell because of the conflict of interest we have. That case is without prejudice. That case is ongoing. Attorney Farrell is using some of the things in that case.
Well, let's take a break right now.
Yes, you were. And I've already shown it once, but we'll get to that in a bit.
While we wait for the other party, did you have a response to Ms. Johnson's request and the basis of your opposing her consent her request for continuance?
Yes, Your Honor. I mean, really, it's a very limited issue. She's here. We're all ready to go. But in terms of disqualification, I was representing a landlord against her in a prior case. There was a confidential settlement agreement. I've not made any reference to that. So I don't know the basis of.
I object, Your Honor. He did subpoena medical records, an extensive history of records that go far beyond this case that could go into the other case, and that case is still can be revisited. And he was not privy to those same records in the last case. He did ask for discovery; those were not given. But he's used this case to subpoena my medical records, a historical amount, not just for what's going on here. And he's created a matter of controversy in order to do that by saying in his response that I could not have been in the ICU and had a visit with my primary care, which was a televisit, by the way. But he tried to say that, and then he subpoenaed her to give a history of all my medical records. That would go back to the 2024 agreement that he and I had.
Not true, Your Honor. She
That is
attached
true. There's a conflict.
Ma'am, let me speak, please. I'll let you speak. You attached medical documents to your motion for continuance. I have a right to subpoena. I've released everyone's subpoena. I don't have any of your medical records. I don't have any of your witnesses. So
Okay,
that
I just got that subpoena today. That subpoena was given to me at 9:45 this morning. I was unaware that he would go that far. I did try to present this conflict. I did try to present this conflict in a motion.
Folks, well, let me just, can I ask you for really, why do you need the continuance? Let's start there.
The reason I need the continuance is because there was first of all, I just got out the hospital, but in the motion, there was in the agreement, the original agreement, there was $1,000 to assist with move out costs. It was not for them to move me out. It was so that I can get help moving out because I can't go back into that building. You just asked me, you said, how could you get help to move out? I said I couldn't do that myself under those conditions because it's uninhabitable. As soon as you walk in, you're overwhelmed with the smell. Somebody said they would charge me that amount. So I said, okay, but they would not release that to me unless I signed a contingency agreement releasing them of all future claims and all this other stuff and tons of all this stuff. And that was not what we agreed to. And that's what I'm trying to get to. But it's hard for me to vocalize that under stress, is that is not what we were getting to. They delayed giving that to me. They said, the only way you'll get that, and they wrote it in this is not what we went over in court, is if you sign this. And he tried to get me to sign a 5-page document that said, you won't do this and you won't do that and you will never do this and you will never do that. And you won't hold any of us responsible and all these other people. And that was not part of the agreement. It was a simple agreement that we just drop claims